7, 6, 5. In this installment of Washington Legal Foundation's Legally Brief, we're joined by John Roberti, a partner in the Washington, D.C. office of the law firm Mayer Brown. John, can you tell us a little bit about the unique challenges posed by federal antitrust investigations?
Absolutely. There are three aspects of federal antitrust investigations that make them unique. First, the stakes are high. Second, the investigations can be global in nature. And third, through incentives created by the government, a company is often faced with numerous cooperating witnesses that cause the company to face a steep uphill climb to prove its innocence. So first, what I mean by high stakes? Well, a number of different things. First, there's substantial exposure in an antitrust investigation. The fines can reach tens of millions of dollars for a violation. And even behind the fines, you'll find private class action lawyers who bring follow-on litigation and bring claims for treble damages. Second, there's jail time involved for executives. And third, an antitrust investigation can curtail business practices that can be important to the company and, as a result, can be very business sensitive. The second reason that antitrust investigations are unique is that they're international in nature. A number of jurisdictions, including the EU, Australia, New Zealand, Korea, Brazil, and South Africa, have all passed antitrust laws. So when you're confronted with an antitrust investigation, it's often a multi-front war. And as you fight that war, you're facing different processes in different countries. And that can be difficult for lawyers and companies that are used to U.S. processes. In addition, regulators around the world have no conscience about fining a company many times for exactly the same violation. The third reason antitrust investigations are unique is there's a culture of leniency that creates unique challenges. Now, let's be clear. Investigations can be initiated from a number of different sources. For example, disgruntled employees may go to the government with information. Customers often complain about business practices. Government lawyers themselves can initiate investigations based on public information. They surf the web or information that's come to their attention through other investigations like merger investigations. But the most common way that an antitrust investigation is initiated is through a cooperating witness. That's because the U.S. government has created an amnesty program that allows a company that admits to a violation and turns in other violators to avoid criminal prosecution and to limit its civil liability. Virtually every foreign government that has an antitrust statute has a leniency program to encourage cooperation too. So what you find is people who want to seek leniency or amnesty rack up a lot of frequent flyer miles in making their confessions around the world. So once the company is faced with a cooperating witness and the first company has gone in, there's incredible pressure on the remaining purported conspirators to plead as well. These incentives mean that in many investigations, a company is dealing with a situation where a cooperating witness has already admitted to a conspiracy or other violation. And that creates a very steep uphill climb in defending against the allegations. So, when confronting an antitrust investigation, it's critical to be prepared. It's critical to respect the government's process and to ensure that all responses to the government demands are complete and correct. In the contemporary legal note we published with the Washington Legal Foundation, my colleagues and I talk a bit about how to accomplish that. But when the government comes knocking, it is rarely remembered as a happy day. It isn't the end of the world either. Companies can defend against antitrust allegations by respectfully and forcefully responding to the government's allegations and asserting all appropriate defenses. We do that on behalf of our clients all the time. And we find that most investigations end by being closed or being settled on business reasonable terms. Even under the weight and the pressures of antitrust investigations and with all the incentives created by the leniency programs, there's no reason to be shy about defending yourself, particularly when you've done nothing wrong.
The contemporary legal note that Mr. Roberti referred to as authored by he and two of his colleagues and published by the Washington Legal Foundation is available to be downloaded at our website, www.wlf.org.